Get ready for the dictation. Dictation will start in 5 seconds. Start. In 2007, Advocate Anand Padmanabhan filed a lawsuit on behalf of two devotees against the temple administration for mismanaging the temple and pleaded that the government appoint new trustees to manage the deity's wealth. The lawsuit was allowed by a Trivandrum lower court, which ordered the government to take over the temple and its possessions. However, the royal family contested the verdict in the Kerala High Court on the grounds that for centuries it had traditionally presided over the temple administration and protected its possessions. In 2011, the Kerala High Court, by a common judgment on a writ petition filed by the successor of the last ruler, held that the petitioner Thirunal Verma, the then Maharaja, or any successor of his family could not claim control or management of the temple under section 18 under bracket 2 of the Travancore Cochin Hindu Religious Institutions Act 1950 after the death of the last ruler. The court thus maintained that the petitioner did not automatically step into the shoes of the last ruler and therefore could not claim management rights over the temple under the provisions of the Act. Disposing of the appeal filed by the royal family, the Kerala High Court issued a direction to the state government to immediately take steps to constitute a body, corporate, or trust or other legal authority to take over control of the temple, its assets and management, and to run it in accordance with the traditions hitherto followed. Aggrieved by this judgment of the Kerala High Court, the Maharaja and the then executive officer of the temple filed two special leave petitions before the Supreme Court. It is this judgment of the Kerala High Court on which the Supreme Court adjudicated. The Supreme Court overturned the High Court ruling and made the following salient observations. The High Court's order is based on the recognitions of the fact that the temple and its assets are not owned by the royal family and that Article 8 of the Covenant establishes a special relationship of Dharamkarta between the royal family and the deity. This special relationship was acknowledged by the Union government at the time of accession. Hence, the family continued to enjoy the right not because of its being a royal family but because of its lineage of having been the custodian for centuries. This relationship is independent of any title that was bestowed on the royal family which granted it any privileges. The Dharamkarta was pre-existing the privy purse abolition, 26th Amendment of the Constitution. The amendment abolished the titles and the privileges attached to it and had no bearing on the special relationship. The High Court has laid emphasis on the fact that Article 8 of the Covenant specifically forms the basis of Chapter 3, Sections 18 to 23 of the Act of 1950, which details the administration of the temple. The High Court has recognized the fact that the purpose of providing a chapter in the Act was to ensure that the rights guaranteed by Article 8 of the Covenant are protected and guaranteed to the ruler and his successors even after the signatory passes away and India converts to a republic. Stop.